Hello, and thank you for joining us for our webinar talking about some of the risks of operating in China, both as a manufacturer and as an importer. Today you'll be hearing from Kathy Ayres, who is a partner and a registered trademark attorney, and also from myself, Jonathan Midgley. I'm a registered patent attorney. We should be talking for about 45 minutes. I want to start by providing some background to IP in China and the reputation it has, and some of the things that are being done to change and improve that. We'll look at some of the trends that we have seen over the last few years and going forward before looking at the big issue of enforcement. We'll then have a look at the various different IP rights available and some of the issues around those, particularly trademarks. So looking at the sort of historical position, China historically and culturally has had a reputation for not paying much attention to IP rights, particularly where foreigners are concerned. Much of this reputation seems to be well earned, and the question is really whether this is still true today. In answer to that, a lot has changed in the last 15 to 20 years. In 2001, China joined the WTO, and with that, certain obligations were placed on it to improve the position of IP and its enforcement in China. Significant improvements have been made over the following years, and this is reflected in the attitude of foreigners in terms of the number of IP filings that have been made, which have been steadily increasing over the last 20 years. 20 years ago, relatively few people even considered filing in China, whereas today China is often on applicants' top 3 or 4 countries, certainly for patent filings. So looking forward to the present now, every 5 years China releases a 5-year plan setting out its aims for the coming 5 years. The most recent 13th plan, which was for the period from 2016 to 2020, addresses the usual economic targets, but it also aims to introduce the desire in China to achieve an annual growth rate of 6.5% to 7% in GDP. Now, whilst the aim is to achieve this partially through domestic consumption, they also want to stimulate innovation and entrepreneurship to develop both the domestic and international markets to aid in achieving this goal. The key point here is innovation. China has historically excelled at low cost, often generally low tech reproduction, but it now wants to move to the next level of innovation by producing its own technology. And the key to this really is protecting that investment in innovation. And this means IP protection, and that means really making sure that the work that's put into producing that innovation is valuable and then protected. As part of that, then, China needs to have this background and structure which gives effective protection to IP. And as part of that, the reciprocal nature with foreign companies, providing that the systems that will work both for domestic clients or domestic applicants and also for foreign applicants. The 5-year plan includes a specific part which relates to IP within it, and this sets out specific targets for the IP environment in China. For example, in 2015, from 2015, the aim is to achieve a doubling of patents per head from about 6.3 to about 12 per 10,000 of population. And also there are specific targets for increasing the number of international applications by Chinese companies from 30,000 to 60,000. All of this suggests a very strong commitment to IP and the use of IP by Chinese firms. So looking at some of the trends that we've been seeing, as we discussed above, there's clearly a political desire for increased IP activity, and this has been in place for some years and has led to a number of incentives for Chinese companies to file for IP rights, particularly patent rights. And this has had a dramatic effect. There's some numbers here that show some of the changes in filings. So you can see there, first of all, the trademark filings. In 2015, 2.8 million trademark filings were made, which is actually more than 5 times that in the US in the same period, and represents about 1/3 of all global trademarks, and that's up about 27%. Similarly, there was about 1.1 million patent filings, which is, again, almost double that in the US, and also it represents an increase of about 19%. And also 1.1 million utility model filings. Utility models are a sort of lightweight patent filing, which many countries don't have, but are very popular in China, as you can see. And again, this 1.1 million represents an increase of about 30%. So there's certainly substantial growth in filings in China. A large proportion of these are actually filed by Chinese companies, and as such, Chinese firms are increasingly looking at overseas markets, and Chinese companies are also increasingly filing abroad. So this enthusiasm to use the IP system may in part be driven by government incentives, and it may be that people are filing simply because there's funding available to do that. But as these rights are in place, and a significant number of them, there's going to be a strong groundswell of people looking to get value out of those rights, and also a vested interest in being able to properly enforce them now that people have got them. So coming to you, a lot of people think, if you're only exporting out of China, do you really need to worry about IP? Is it really that important? You're simply using China as a manufacturing base, but then your market is outside of China. Well, in answer to those questions, really, the answer is yes, both in terms of the risk of falling foul of other people's IP rights in China, but also in terms of controlling what happens to your own IP in China. So looking at the issue with other people's IP, as you can see, a substantial number of IP rights are now in place, and if your technology or brands are covered by IP held by someone else, then you may find yourself on the receiving end of legal action from them, even though you're not actually selling in China. This can result in injunctions to stop production, seizure of goods, damages, and so on. So with the proposal to increase IP filings further, that risk is only going to get worse as more and more people within China hold IP rights. This can have a disastrous effect on your business if suddenly you're not able to produce the goods you want to sell on your international market. Even if you ultimately win the case that's been brought against you, a court case can be very distracting and very disruptive to your business in the interim. So it is therefore important to be aware of other people's IP, and this may involve various steps such as clearance searching. One other point on this is you may think it's okay to rely on your Chinese subcontractor or supplier to make sure that they're checking to make sure there's no IP rights that are infringed. But as we've seen in the past, that there's been less interest and less concern about IP, and so they may not be so worried about it and may not pay the attention that you might do in terms of ensuring that the products you're producing don't infringe other people's IP rights. And also, they may not be as badly affected if they can't produce the goods that you are asking them to produce. There may be only a small part of their business where it may be the entirety of your business. If production suddenly stops, they may not be so concerned. So the important point there really is to make sure you do your own due diligence and don't rely on your Chinese subcontractor or supplier. So that's other people's IP rights, but what about your own? Is it worth getting your own IP rights? Again, if you're only exporting out of China. So yes, you need to be concerned about competitors producing a competing product, which they may sell domestically, which may not be a problem, but they also may export it and compete on the same markets that you sell in. So there's a risk of contamination of the brand and also reputation, quality reputation, if they're producing goods that are similar or even confused with your own. So it's important still to consider getting your own IP rights to try and stop this copying. You may also want to enter the Chinese market in the future. And again, if the market's already been serviced by somebody copying your goods, it may be very difficult for you to break into that market, even if you wanted to. And you also need to bear in mind the actions of subcontractors. If you're using subcontractors to produce goods for you, it may be fine whilst they're doing that, but your relationship with them may end, whether on good terms or not. And they may decide that they want to continue producing the goods they've been producing and sell them on the local market or even, again, internationally. So again, having your own IP rights allows you to control, to some extent, what they're actually doing and what they do after you've ceased to be working with them. So coming on to enforcement, this is the sort of the big question that many people sort of feel it questions whether it's worth getting IP protection in China. And the commonly held view is it really worth bothering getting the rights in the first place if you can't then enforce them subsequently? Well, I've already said that Chinese companies are filing more, and this increases the risk of you being on the receiving end of IP suits. So having your own IP strategy and rights will not only give you something to use to protect your own business, it can also be a disincentive to others who might be coming after you with their own IP rights. And it can also provide you with an awareness of what risks are out there from similar brands and technology. If you're filing your applications for your own trademarks or patents, you should, as part of that process, become more aware of what's out there that's similar in terms of brands or similar in terms of technology. So this should give you an idea of some of the risks that are out there. And of course, with that, you may look at doing clearance searching, as I've mentioned before. If you find someone is using your brand or technology, the question is, what can you do about it if you've got no rights? The answer is you can't do very much at all. Whereas if you do have some rights, at least you've got a starting point then to try and take some enforcement action. You can try and keep technology secret. That's very difficult, particularly when you're dealing with subcontractors and local agents. Again, if the relationship ends, particularly if it ends badly, then legal agreements and confidentiality agreements may not be very strong at maintaining the leakage of information, both in terms of employers moving to different companies, but also with those subcontractors themselves. However, if you've got strong IP rights, as I've said before, then at least you have this protection that you can enforce against historical suppliers, against copying. On the positive side, China has a very good legal framework, and this has been improving significantly over the last couple of decades. It has a very effective patent office for processing of applications, and the quality, certainly of patent examination, is very good, with laws that are similar to those of the European Patent Office on which the law was based. And so the result of this is you get high quality patents that have been properly examined and should stand up reasonable scrutiny in court. Associated with that, there are various courts now in China that are used to handling IP matters and very competent at it. And this includes the specialist IP courts in Beijing, Shanghai and Guangzhou. So coming on to the question of whether IP can be enforced in more detail, there's a few preconceived ideas that people tend to hold about protection in China and enforcement. Often people think that foreign companies just can't win against Chinese companies. Even if you get enforcement, Chinese companies can just disappear into the woodwork and then reappear down the road and carry on doing what they were doing before. And also that judgments are simply just not enforceable. There's too much resistance and local protectionism that stops enforcement taking place. So looking at the first point in terms of foreign companies, yes, there may have been this issue historically, or certainly this perception, but there's some interesting statistics here. According to Gang Feng, who is the court judge in the Beijing IP court, in a presentation he gave, he said that 72% of plaintiffs in the court, the Beijing court, won their first instance civil cases in 2015. And out of those, the foreigner plaintiffs actually had a win rate of 100%. So all foreign plaintiffs won their cases, about 63 cases in 2015. So it doesn't seem that there's a foreign bias there, certainly not in the Beijing court. There may be reasons for this. Foreigners may be more motivated in terms of the cases they take forward, and they may only pursue stronger cases. But even so, 100% seems pretty convincing to suggest that there isn't this bias that historically people have thought has been there. In terms of companies disappearing, that is still an issue, and enforcement of judgment is improving over time, and making that ability for companies just to slip away and reappear harder and harder. In terms of the effect you can achieve, you can get damages awarded in court cases, but this can still be problematic in terms of getting the damages actually paid up, and often Chinese companies perceive a damages award as simply the next stage in the negotiation before a sort of final settlement. So there may still be steps to be taken after an award of damages has been made. Having said that, the judgments in the courts are comparatively quick, and often quicker than in the UK, typically taking about 6 to 12 months from issuing proceedings to judgment, and are often cheaper. Against a Chinese company exporting to Europe, it may actually be quicker and cheaper to stop them at source in China than trying to take them on in your home markets, potentially in several countries. So cutting them off at source can actually be a very effective way of achieving a global effect against a Chinese-sourced competitor, Goffia. So coming on to some of the sort of options that are available in terms of enforcement action. There are various options available for taking action, and this will depend really on what sort of IP you're enforcing, the type of product, the value of the infringement, and so on, as to which one is the best way forward. The simplest, most obvious solution is civil court proceedings, and this can be very effective at providing injunctions, damages, delivery, getting destruction of the goods, and as I was noted above, the courts are providing pretty high quality decisions, sensible decisions. There is also an administrative patent enforcement option in China. These are provided through the Chinese intellectual property offices. And the IPO in China have several regional offices, and these can be used to obtain these administrative patent enforcement. And also there's a copyright office through which you can get this as well. These are relatively low cost and fairly fast, and they're particularly good for trademark and copyright infringements, but also can be used for gathering evidence on more complex patent infringement cases. These bodies can carry out raids, seize and destroy goods, impose injunctions, and impose fines in some types of case. However, you can't get damages with these sort of cases, so they're good for stopping infringing activity, particularly if there's no real damage being done. They can also be quite useful where evidence is hard to get, as these bodies can then help you in terms of obtaining the evidence that you might need. As I said, this can be very useful for patent cases where getting evidence can be very difficult. At the moment, these administrative enforcement options are really mainly used by Chinese firms, but with good local representation, they can be quite an effective option with relatively low cost compared to civil court proceedings. There are other options such as criminal prosecution via the police, and these can sometimes be referred from the administrative patent enforcement options, but can be done directly through the IP owner. The other option is customs seizures, which is particularly good for counterfeit goods. So you register your IP rights with customs, who monitor both imports and exports in and out of China. And all the main IP rights can be registered with them, so they can keep an eye on things in terms of your own IP. And they have powers to confiscate goods and also impose fines. So I just want to quickly go over some of the IP options that are available in China. China has a similar sort of selection of IP rights, but I'll just go through those briefly now. So patents, as I've said, China can provide patents. The patent system is similar to other countries, and as again I mentioned before, that's modelled on the EPO law and has very similar sort of structures to that. In terms of the quality, it's very good, and often you find that the Chinese patent examiners will refer both to the US and European applications in terms of the issues that are raised, and are raising similar sort of objections. You can get a patent via the PCT or directly. Chinese patents don't cover Hong Kong, but they can be used as the basis for a registration in Hong Kong. Hong Kong has its own registration system, which is based upon Chinese or UK or European patents. And patents in China last for 20 years, similar to most countries. So China also has registered designs. These are used for protection of the aesthetic appearance of articles, including shape, pattern, and colour. They're fairly simple to apply for, and the procedure is relatively straightforward and is similar again to those in the UK and Europe. The designs are submitted and are examined only for formal matters such as the quality of the drawings and so on. There's no actual check in terms of whether the designs are similar to existing designs. They're cheaper than patents and relatively quick to get, typically taking about a year, and they last for about 10 years. as I mentioned before, China also has utility models, which are a sort of lightweight patent. They're really designed for sort of simpler products, primarily to cover shape and structure of a product. So they're not very good for covering methods or for complex inventions. So that makes them pretty good for sort of lower inventiveness inventions, but also for short life products where you don't want to invest a lot of time in a full patent application and process. The procedure is fairly simple for registration. Again, similar to designs, there's only a formality exam, so they're not examined in terms of their novelty or inventiveness. So again, this makes the process relatively cheap and also quick, typically taking about a year for the registration to take place. Again, like designs, utility models last for about 10 years. These historically have been relatively unused by overseas companies and are primarily used by Chinese companies. But they do actually provide quite an effective and low-cost way of getting protection in China. And actually can be used in parallel with a normal examination, not normal patent application. So you can apply for a utility model and a patent at the same time. This means basically you should get your utility model granted relatively quickly, which means you've got some protection in place whilst your patent is going through the normal examination process. At the end of that, you can then sort of drop your utility model and use your patent, which gives you the sort of stronger protection of knowing that it's being examined by the Patent Office and should stand scrutiny in a court. You can obtain utility models via the PCT as well, although there are some issues in terms of applying for both a utility model and a patent from the single PCT application. So if you want to go for both, it's better to apply for those separately via the national route rather than via the PCT. Of course, the other big part of IP protection in China is trademarks. So I'm going to hand over to Kathy now, who's going to talk in a little bit of detail about the issues around trademarks and some of the risks associated with doing business in China. So I'll hand over to Kathy.
Thanks, Jonathan. Before we talk about trademarks and copyright, I just wanted to highlight IP scams. IP scams often come up when we talk about China. The scam, I think, which we've all seen, in fact we get loads of them all the time, is in relation to domain names. This is where you'll get an approach from a Chinese firm who may style themselves as a domain name registration specialist. They may style themselves as a law firm, and they'll be telling you that one of their clients has approached them with a request to register a domain name, and oh, they did some trademark searching and they found that the trademark, which forms part of the domain name their client wants to register, is actually your trademark. As I said, we get these quite frequently, saying someone wants to register scotlandyork.cn or whatever. Typically, these are basically just attempts to persuade you to register your domain names in China. Because if you think about it, what incentive would a firm have to contact you to say that one of their clients wanted to do, basically to rip you off? And there'd be a massive conflict of interest there, and quite clearly these things aren't genuine. Certainly, whenever we've looked into any threat, you soon find that there's no application on file to register a given domain name. We see similar approaches, less commonly, but we see similar approaches in relation to trademarks as well, where a Chinese law firm has found that a UK-based client hasn't registered its trademark in China. They'll approach them and try and persuade them to do work in China. I mean, obviously, we would strongly recommend that you never act on one of these approaches. Always get your own contacts involved. Clients will often find that they get offers of help from their Chinese distributors or Chinese manufacturers when they start manufacturing or distributing in China. And often that distributor or manufacturer will say, why use your own contacts back in the UK? Use our contacts, it'll be so much cheaper for you to get registration in China through this route. I mean, the cost of obtaining trademark registration in China is going to be between £1,000 and £2,000 if you use a firm like ourselves, and most probably it's going to be nearer the £1,000 end of the spectrum, and that's for a registration which lasts for 10 years. That is a relatively small amount of money, and it's a very worthwhile investment when the alternative is being ripped off. We have concerns about people using Chinese contacts due to quality, because there's a vast number of Chinese law firms, and some of them do very, very little international business, and some of them may do very little intellectual property business. You won't know if you're using someone who's been recommended by your Chinese distributor. But the bigger problem really is making sure that the rights end up in the right ownership. The filing receipt in relation to a Chinese trademark application is actually only in Chinese. Sometimes you'll find the postcode for the company put on in English language characters, but basically everything is in Chinese, and so it's incredibly difficult for someone to tell whether a trademark application has actually been filed in the right name. And basically you're just asking to be taken advantage of if you proceed in this way. There's also the worldwide problem of unofficial registers. Typically when you file a trademark application in the UK, you will have at least 2 or 3 approaches from people who are offering you registration services which are inflated cost. They will look somewhat genuine. They will often have a logo on them which resembles the logo of the European Union. But these are just fraudulent requests for entry of your trademark onto an unofficial register, which you pay a lot of money for, and then you're basically on a mailing list where other people can try and dupe you as well. Definitely to be avoided. And moving on to talk about trademarks proper now. Chinese trademarks don't cover Hong Kong, and there's absolutely no link between the two processes at the moment. Obviously that may change in future. A trademark is a distinctive sign which distinguishes your business from those of other people. In 99.9% of cases, when we're registering trademarks, we're registering words or we're registering logos. Other things can be trademarks, such as sounds and smells and the shapes of the goods or their packaging, but those are very rarely dealt with in practice. So most times we're looking at words and logos. We always recommend that people file early for protection, whichever country you're dealing with. But obviously it's particularly important where you've got a country which is called a first-to-file country. And what does that mean? That means that the first person to file a trademark application is the organisation which then acquires the rights to the name. And China is certainly a first-to-file jurisdiction. For that reason, it's always sensible to have trademark searches done before you're starting to use a trademark in China. And that, when I say starting to use, that could be starting to apply the mark to goods which you're having manufactured for you in China, or when you're starting to sell into the local market. Those searches can obviously save you a lot of money and save a lot of surprises later on. The application procedure in China is fairly conventional in that you file your application, it's examined. Once the examination process is over, it's advertised for opposition purposes. Once the opposition period is over without objection, the mark is then registered, and the registration has a 10-year life starting from the date of application, with renewals being due every 10 years, and the registration stays in force indefinitely. So far, so completely normal throughout the world. However, there are some wrinkles. Like a lot of countries, you have to think a little to operate the application procedure cost effectively. You're allowed to cover 10 items in a trademark application in terms of the list of goods or services you want to cover, and that's per class, before you start incurring extra fees. So it obviously makes sense to bring your list of goods or services you want to cover down to 10 items or less. That isn't as hard as it sounds, because in China you're often rewording the specification of goods or services that you've used in connection with applications in the UK or European Union to meet with local requirements. Quite often, the terms that you've obtained registration for in the UK or European Union just won't be understood properly in China, just won't translate properly. And so you will always be changing the wording slightly and probably making the terms a bit more general to meet with Chinese requirements. Filing receipts we've often found are very slow to issue in China. I mean, most countries in the world are working towards a system where you file the application, you get the filing receipt on the same day. That's certainly the case in the European Union and in the UK, and in the USA indeed. So it's a bit strange to suddenly find there's a country where you've got to wait 1 or 2 months for a filing number out of the authorities. And in fact, it can often be a lot longer than that. I've recently filed some applications where we've had to wait about 5 months for the application number, which is a difficulty because there's a Chinese distributor who's waiting for confirmation that the application's been filed, and they want to see a filing number to be satisfied. But this is simply a volume issue. Once again, apparently China has received a record number of trademark applications in the last year, and they're simply struggling to keep up. A real Chinese wrinkle is the issue of subclasses. When you register trademarks in most countries of the world, you have to classify your goods or services into one of 45 different classes, and that's a system called the NIS classification. The first 34 classes relate to goods, and the last relate to services. But the Chinese have gone further, and they subdivide those categories into subclasses, and they generally consider goods or services which are in different subclasses to be fundamentally dissimilar. So if you want to operate the registration system in a savvy fashion, what you do is you make sure that you cover as many subclasses as you can, and then effectively you block out the whole class in relation to your trademark and one similar to it. Oppositions are allowed for, the process being more like the European Intellectual Property Office than the UK Intellectual Property Office, in that if you oppose an application, the applicant doesn't actually have to engage with the process in order to be successful. In the UK, what happens is that when you file a notice of opposition, the applicant will have to file a counter-statement, basically saying why they think the opposition shouldn't succeed if they want to keep their application going. And if they don't do so, then they're deemed to have abandoned their application. That doesn't happen in the EU IPO and before the Chinese authorities. The applicant can just sit there, incur no costs, do nothing, and wait to see what the decision, how the decision falls. So frustrating sometimes for opponents, but that's just the way it works. Registration is usually obtained in around a year, but you're going to receive a lot more time if you've got any official objections. Once official objections are raised, or once oppositions are encountered, then you're in it for the long haul, you're in it for a few years. And one of the reasons for this is that when an objection is raised on an application, the matter has to go to appeal, and the appeal board is very busy. So it can be many years before you receive any reaction from them. If you do get an official objection at the examination stage, then you need to be aware that you've only got 15 days to respond, which is a very short deadline if you've got quite substantive issues to consider. And it also means that if you have Chinese trademark applications ongoing, it's always as well to be aware that you may need to be contacted at very short notice, and so don't swan off on holiday without letting someone have very good contact details for you, or for a deputy who can handle matters in your absence. China is part of the Madrid Protocol system, which is a system which enables registration of a trademark in about almost 100 countries in the world now. It's very similar to the PCT system for patents. But there are limitations of using this route. It's really cost effective and we use it a lot, but it's probably not the best route to obtain registration in China. It works for the moment, but I think that's because most people don't view China as a major market. But certainly with Brexit and with the evolution of China as a real consuming force, that's going to have to change. The limitations of the Madrid system are important, and so I'm giving their separate slide. It's important to remember that the mark you apply for in China can only be the same as the mark you've applied for in your base registration. And we'll discuss in a minute that that's an issue, a real big issue to be aware of. The Madrid Protocol system also involves a delay in obtaining registration because the application is filed to the UK Intellectual Property Office or the EU Intellectual Property Office, is administered at the sort of a formality checks done at that stage, and then the application passes to the International Bureau of WIPO, the World Intellectual Property Organization, which generally takes around 4 to 6 months to process it and then communicate details of the application to the various countries which have been designated. So you're building in 4 to 6 months of delay, which can actually be quite significant. And a problem we've also had with Madrid Protocol registrations or Madrid system registrations is that while the International Bureau issues a registration certificate about 4 to 6 months after the application is filed, and the mark isn't registered at that point. The mark has to be examined for compliance with national law before it's actually protected in that territory. Now, when the mark is protected in that territory, typically you will receive a letter from the International Bureau, and you may have some form of communication from the local office attached to it. But it's not the same as a registration certificate. And this has proved a real issue for us recently for a client whose Chinese distributor really wanted to see a registration certificate. They weren't happy with the paperwork we'd sent them from the International Bureau. And so we had to go through a process of obtaining a formal registration certificate from the Chinese authorities, which is perfectly possible and doesn't cost too much, but it did take 2 to 3 months. And obviously, if you've got an agreement which is waiting signature with a Chinese distributor, that kind of delay is certainly not helpful. So if you are looking to exploit your mark in China by selling products in China, and you're using the Madrid Protocol system, probably a good idea as soon as the mark is protected in China to request that formal registration certificate so that you have it ready when your Chinese distributor asks for it. You need to think very carefully, as I mentioned earlier, about what to register when you're doing business in China. First of all, you'll need to create a Chinese equivalent of your company name. Now, if you're going to be trading in China to any extent, you should have one of these already. And obviously, you need to be consistent and use the same version of the name across all the places where your company name is used. Even more importantly, you need to create a Chinese version of your trademark. It's most unlikely that the version of the trademark you use in the UK is going to be the version of the trademark you use in China. And thoughts needed about exactly what to adopt. In the old days, and then back in the 1990s, when trademarks in China were still a very new thing, many law firms offered to create Chinese language versions of trademarks for their customers. Unfortunately, when those marks actually got to the stage of being used in China, most marketing specialists threw up their hands in horror and said, oh, there's no way you can use these because that character is inauspicious, that character is unlucky, and basically that's not going to work as a brand for a Chinese market. But I think most people are more sophisticated nowadays and get a local marketing or language specialists involved to create the Chinese version of the mark. This will typically not be a straightforward transliteration of your trademark, so it may actually not sound at all like your trademark in when spoken by a Chinese speaker. Typically, it will be something which evokes the feel of the brand, and so it may actually sound completely different. This all leads, of course, to the fact that you've probably got to get a number of trademark registrations for your brand in order to protect it properly in China. You're almost certainly going to want to register the version of the mark you use in the UK or in most of the world, because obviously you don't want Chinese companies to be able to control that. You may also register a transliteration, so that's something which sounds similar to the UK version, but it may not be the version you actually use in China. You will also register the Chinese version, and you may also register a conferred version. So what's that? Well, when you start to use a trademark in China, and assuming you haven't had a Chinese language version of your brand produced, then you may find that the Chinese public confer their own version of the trademark on your product. If you find out about this, it's very important to take action quickly, because there have been cases where a trademark which was conferred upon on a product by the local market in China has been registered by a third party, and it's been extremely hard, or practically impossible, for the brand owner to get control of that version of the trademark back again. So if you do find that the Chinese public have given your mark a brand, your product a Chinese specific brand, very important to act instantly and register that to make sure that you get control of it. As you're going through the trademark process, and certainly when you've got registration, you need to think about policing your brand. As Jonathan mentioned earlier, some of the flashpoints where you're going to encounter problems are likely going to happen when you change manufacturers or you change distributors. We've certainly had cases in the UK where a company has changed distributors, or rather their products being delisted in favour of a cheaper and an inferior quality product, but the retailer has continued to use their trademark. And if that kind of thing happens in the UK, there's obviously enormous scope for that happening in China, where there may not be quite as much appreciation of brands as in the UK. So very important, when you change manufacturer or change distributor, check what they're doing afterwards, make sure they're not infringing. More generally, making regular market checks to see what's available and see whether your rights are being infringed is also very, very, very important. And one way you can do market checks is through trademark watching. I've run currently about 200 trademark watches for various clients, and the purpose of those is to pick up trademark applications which are filed potentially in any country of the world and which have similarity to the client's mark and which are being registered in similar categories, or rather classes which cover similar goods. It's a really effective way of picking up problems early, because often the trademark will be advertised for opposition purposes a long time before any product actually hits the market. So you can often really nip matters in the bud and save yourself a great deal of cost and heartache. Particularly important to pick up to get watches in place early to pick up bad faith filings with respect to the Chinese market. And you can watch both on UK versions of the trademark and also on Chinese versions. Watching on Chinese versions of the brand is a bit more complicated and a bit more expensive, but it's perfectly possible. Once you have a trademark registration, it doesn't stay in force indefinitely, even if you pay renewal fees, if you don't use it and other people want to use similar brands. Nearly every country in the world has a facility whereby trademark registrations can be cancelled on the application of others if that brand hasn't been used for a certain period of time. In the UK and European Union, the length of time is 5 years. But in China, you only get 3 years from the date of registration to bring your trademark into use in China. It's not a very generous period, and you do need to be alert and get local advice if you're in a situation where you haven't used your trademark and the 3 years has come round. You might think about refiling. You might think about other action to keep your rights going. As Jonathan mentioned, there are customs procedures in place which enable imports and exports of infringing goods to be seized, so important to get those in place too. Relatively low cost way of enforcing your rights. On a related point, we found that if you're manufacturing in China, you are slightly vulnerable to getting pulled into fights inadvertently. We had one instance where a client was manufacturing in the same company as a competitor, and the manufacturer inadvertently used a feature in the client's products which the competitor thought was their proprietary thing. And due to that, they decided to embark on some tit-for-tat activity, in spite of the fact that our client was innocent, was just pulled into this inadvertently, and decided to do some bad faith filings for our client's trademarks in certain jurisdictions, which caused quite a lot of extra cost and an awful lot of worry for everyone concerned. So you do need to guard against that and to be wary. Copyright gets a special mention in China because, a bit like the position with utility models, you find utility models are greatly used in China, really not very much thought of elsewhere. Copyright registration is incredibly important in China, but not something that's even possible in most countries of the world. In most countries, copyright, which applies to original literary or artistic works and includes computer programs, copyright exists automatically as soon as the thing is recorded in a physical form. There's no need to register, indeed there's no facility for registering. The right just automatically exists. And it extends to other countries by virtue of an international convention, or rather one of a number of international conventions which grant reciprocal rights. So Chinese copyrights will be recognised in the UK, UK copyrights recognised in China. But registration of copyright is important in China, and it's done on a large scale by Chinese companies because it makes enforcement so much easier. Duration of copyright is a bit shorter than in the European Union, where you're talking about author's life plus 70 years in most cases, but still you get 50 years, and that's going to be more than enough to give commercial protection in most cases. The reason copyright registration is important is because it's useful for proving ownership. It's a relatively quick process, and although you do need various documents, such as identity documents, documents proving ownership of the trademark, some samples, ownership of the copyright work, which could be a trademark, some samples of the work and a brief description, it's not too onerous and it's certainly well worth doing. As I mentioned, you can consider this type of protection for logos, which can be copyright works, as they're artistic works, as well as for things like software, which I think is the major usage of the registration of copyright. 2017 is the year of the fire rooster, and the rooster is associated in Chinese astrology with being a hard-working sign which shows great perseverance. You need both of these in bucket loads if you're going to make Chinese IP work for you. China is a huge opportunity. It's got a very different culture and a very different language system. These three factors mean that we shouldn't expect getting IP right in China to be particularly easy, but it's nowhere near as bad as people make out, and it's certainly something you need to engage with. Thanks very much for listening to us today. If you have any questions, please feel free to get in touch. Our contact details are on the last slide.